Well, I want to shift gears. I want to move from the theory to the practical application of originalism. Whenever you interpret the Constitution in light of history, which is what originalism is, you have to interpret history. And too little, it's an obvious point, but too little has been made of that. And how well you interpret history is a direct function of how well you're interpreting the Constitution. And what I want to do is use one case, Boumediene versus Bush, decided in 2008, as an example of the use of history to support or distort the Constitution. And my remarks will focus entirely on that opinion. Boumediene was the third in a trilogy of Supreme Court cases arising from Guantanamo Bay, the naval facility there, and the detainees. Military tribunals had found all the detainees to be enemy combatants. And the question in the first of the two cases in the trilogy was whether the habeas corpus statute that was then on the books, it was 28 U.S.C. 2241, reached out to Guantanamo Bay and permitted these detainees to bring cases as they had in the U.S. District Court for the District of Columbia. The cases, in both cases, our court said no, the habeas statute didn't reach Guantanamo Bay. And in both of those cases, the Supreme Court said, oh, yes, it did. And twice, Congress reversed the Supreme Court. I wrote the opinions in both of those cases, and then ultimately wrote the opinion in Boumediene. So what I'm about to say about Boumediene, you can treat as sour grapes, or, if, as I prefer, as informed criticism of the Supreme Court. So the issue in Boumediene was as follows. It was whether, because Congress in the Detainee Act and the Military Commission Act, which I won't get into, had deprived judges, justices, and courts of habeas corpus jurisdiction over these detainee petitions from Guantanamo. The question is whether that violated the suspension clause of the Constitution. And all of you have that little booklet with the Constitution. If you turn to page 9, it's Article 1, Section 9, Clause 2. I'll read it to you. It says, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. Now, the suspension clause has always been a riddle. It's never really come to be interpreted in the Supreme Court. There was one immigration case that was close, but Boumediene is the first case. And the reason it's a riddle is it limits when Congress can suspend the clause, but never guarantees that the clause or that the writ of habeas corpus shall ever exist. The Supreme Court has not done a very good job trying to solve that riddle, but that interpretive problem is not one that I'm going to discuss. What I want to discuss is the following. All of the justices in Boumediene, both in the majority and the dissent, agreed that the suspension clause at least preserved the writ of habeas corpus as it existed in 1789. You see the historical question, the originalism question that poses. And there are a couple of theories that you've heard about today and probably will hear about later on about originalism. There's the original public meaning theory, and there's the original intent theory, and so on and so forth. Suppose the theory is original public meaning, and that is what the words of the Constitution would mean to the reasonably informed citizen in 1789. And so we go out to the streets of Philadelphia at 1789, and we stick a microphone in front of Mr. Citizen, reasonably informed. What does the writ of habeas corpus mean to you? And he would say, how do I know? Ask the lawyers. Or he might say, well, whatever the Englishmen get, that's what I want. Well, the Supreme Court never mentioned the theory of original public meaning. Both the majority and the dissent accepted the proposition that they had to determine what the scope of the writ of habeas corpus was in 1789. And that's what we tried to do in our court. The question arises because there is doubt whether the writ of habeas corpus in 1789 or in 2008 reached geographically beyond the sovereign territory of, in 1789, England, or in 2008, the sovereign territory of the United States. Guantanamo Bay is not now, has never been, part of the sovereign territory of the United States. We occupy Guantanamo on the basis of a lease with Cuba. And the Congress of the United States has declared that Guantanamo is not part of our sovereign territory. A line of Supreme Court decisions says that's a political question. It's not for the courts. So we accept the proposition Guantanamo is not part of our sovereign territory. I remember working at home on this question of the scope of the writ of habeas corpus. And it was a snowy day, which is why I was working on it at home. And it suddenly struck me. I looked at the words. And that's the first thing you should do. Can't suspend except in cases of invasion or rebellion. Well, that suggests a geographic scope within the United States, does it not? Rebellion or invasion. So I was thinking about this, and it suddenly occurred to me that I ought to look at the lectures that Sir Robert Chambers gave at Oxford during the period of about 1750 to 1775. Chambers took over from Blackstone, and he was the Vinerian professor at Oxford of law. So anyway, I went to my home shelf and pulled off one of the volumes, which I had. And the reason I had it is because I'm somewhat of a Johnsonian, but that's another story. And I've had this experience a number of times in my career, but I cracked open one volume. I never look at the index. I cracked it open. There it was. It was a lecture on the scope of the writ of habeas corpus, how far it extended. And Chambers said it never went beyond the sovereign territory of England. And he quoted Lord Chief Justice Mansfield, the greatest lawyer in England in the 18th century. And Mansfield said the same. And the reason, there were a number of reasons for this, not the least of which is that the great bulwark, as Blackstone called it, of English liberty was the Habeas Corpus Act of 1679, which said quite clearly the writ doesn't extend beyond the sovereign territory. And it prohibited the king from sending people, prisoners, to places like Jamaica, which was the equivalent, the functional equivalent of Guantanamo. Well, anyway, so I thought it was legitimate to rely on Chambers, even though his lectures were never published in the United States until 1986. But we're doing historical research, and it's the kind of thing that you, by the way, you cannot do good historical research sitting in front of a computer. You've got to go into the stacks. You've got to go into the library. You've got to turn half a library over to find some of this material. That's how difficult good, solid historical research is.